Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started. All righty. Wow, today's topic is a really interesting one. It is dirty tricks in divorce. I'm April Jones. I am the founding attorney at Jones Law Firm PC. We've been serving clients for over 20 years, since 2000. So we're really excited about that. And I have two of our senior attorneys on to help today, Patrick Barkman and Aaron Young. So do you guys want to introduce yourselves real quick and then we could jump right in? We've got some good stuff.
I'm Patrick Barkman. I've been with the firm for 2 years now. I've been practicing law for 23 years, and I'm licensed in Colorado, Texas, and the Cherokee Nation.
Thank you, Patrick.
Hi, I'm Erin. I have been with April about a year and a half. I've been licensed about 17 years, and I've been doing family law for about 6 years at this point, exclusively.
All righty, so then let's get after it. I think people already know I've been an attorney 30 years now, and this is always an interesting topic. So dirty tricks that people use in divorce. Let's kind of do this like a round table. This is one of my pet peeves. It's probably because it's happening to a dear friend of mine right now, where the opposing party and the lawyer just team up and just stick with the ridiculous. Lots of money on the line, and they drag it out forever. And you're just spending money. You're just burning attorney's fees. They force you to burn attorney's fees on your side. They're burning attorney's fees on their side. And what I come to think of that trick is is it that lawyer's business plan? Because what do you think of that, Patrick? Because you get to the end and you're not, the wife of 40 years is not going to get 20% of the marital estate. Like, it was always a foolish position, but you take a position that you won't win on at trial, but it forces the case to trial. That's the position in a nutshell. What do you think of that, Patrick? And then you, Aaron.
Yeah, that's definitely a pet peeve of mine too. I mean, you can understand it maybe if the other side is representing themselves or pro se, but lawyers should know better. And that's the kind of tactic that makes people hate lawyers, just grinding the case on, generating fees, making the other side waste money, taking ridiculous positions. And it's always been my view that as the lawyer, it's our job to tell the client, you're being ridiculous. We can't win this position. We should move on to something else we might be able to win, or we should try to settle. I feel like we owe our clients a duty to be straight up with them. But yeah, that's a huge pet peeve of opposing attorneys. We won't name any names, but we all know who we're talking about, who grind cases on endlessly and dramatically increase the expenses when everybody knows, for the most part, how the case is going to end up.
Aaron?
Yeah, I mean, 100%, Patrick. And it's not even always with an attorney. Sometimes it's simply the opposing party, and it's a form of punishment, right? They know that their ex is spending X dollars, to pursue this divorce, and they want them to spend every possible dime they can spend, not caring that they're punishing themselves equally. But yeah, I mean, we absolutely want to avoid that. We want people to take a reasonable position. We want people to take a defensible position, and we want people to conserve their resources, so that they're not left, completely bankrupt after a divorce. It doesn't have to be completely devastating financially, to go through a divorce.
And if you find yourself in that situation, if it's someone who's listening to us on our webinar, one of the things I suggest you do is get another opinion. If your lawyer is just feeding into like the perfect ideas you have for how your case is supposed to go, and it's looking really expensive, and the other side won't settle, give us a call. We can tell you if the position you're taking is one that you're likely to win, likely to never win, may or may not win. And if you're just being fed what you need emotionally, only to lose your estate in the end. So that's really important. If you can just kind of separate how emotionally fulfilling it is to keep offering your ex, pennies and watching them like scream and squirm, but you're also losing. You're losing a lot. So give us a call if you think you're in that situation and just kind of want to double check if your direction is the right direction or if you're being manipulated, because we hate that. Okay.
Right.
Here is,
and we'll be honest with you. We'll be blunt and upfront and honest with you. And if your position's good, we'll tell you the position's good and it's worth the fight. But if the position is bad, we'll tell you, you're probably not going to be able to win on that. Let's move on.
Yeah, we practice law like we play chess around here. So if there's some other move we can make, we'll make that move. But if you're going to lose your queen every time you make this move, we're going to tell you, let's move something else on the board. Okay. All right, let's move on. Here's one I know Patrick will probably have a little to say about when people try to relocate the kids prior to filing. And this is a tricky one. If they do it right, it can really get you. So one I see a lot is we'll just use gender just for ease. Let's say the mom is wanting to leave the dad and promising that they want to work things out, but just let me go home to my mother in Texas and just give me, 180 days to think about it. And then I'll let you know. And Patrick, why don't you weigh in on that and why someone needing 181 days to think about something is always a problem?
Right. Yeah. Well, I mean, even beyond that, 181 days, 182 days is the magic number for establishing jurisdiction in Colorado. And we've seen lots of cases that are like that.
In any state, Patrick, sorry to interrupt, but in any state.
And Aaron, why don't tell us what that means? I didn't want to talk the whole call. Aaron, tell us.
Okay, yeah, good point.
The significance of
jurisdiction.
Yeah,
jurisdiction just means what state you're going to fight in. Okay, and jurisdiction, typically, whether we're talking about a divorce, jurisdiction follows the residence of the parties or the residence of the kids. So if both parties are living in Colorado and they lived here for 180 days, then Colorado is going to hear the case. But if one party moves to another state and stays there for the magic number of 181 days, then they could file for the divorce in that state. And then that puts the spouse that's still here at a disadvantage, because then you're having to fight long distance. And sometimes it does happen, like April described. They're saying, "Hey, I just need some time to myself. The kids and I are going to go stay in Texas or wherever." And sometimes, unfortunately, one side will just pack up and go and take the kids with them, or some of the kids with them. I've also had that happen, and go to another state and maybe cut off communications. That's definitely a dirty trick. And that puts you now, what you can do if that happens is you can try to challenge the other state's jurisdiction on the grounds that the party that moved to that state was acting in bad faith. In other words, if you take off to another state and you haven't discussed it with your spouse, you just grab the kids, grab some stuff and take off and hide until 181 days has passed, you can argue to the judge in that state. And if it's Texas, I could argue it for you. You can argue to the judge in that state, you should decline to exercise jurisdiction because the other side is acting in bad faith.
But you'll probably lose because the other Texas, Texas is going to be like,
that's probably true. Yeah.
These are citizens now. These are our citizens of the United States, Texas, and jurisdiction is here. It's not.
Well, I want to clarify the thing about the kids, because Patrick was talking about the parties, meaning mom and dad, but really the 180 days relates very specifically to the children. And once a state is the home state of a child, another state actually does not have jurisdiction to enter orders. So even if mom still lives in Colorado or dad or whoever, and child was removed to, we can continue with Texas, has been removed to Texas, if they have lived there 6 months, Texas is it. That is the only state that can enter orders about that child or those children. So it's really important. And if something like that happens without your consent, you're going to want to file long before that 180 days, especially if you want the case to remain in Colorado.
Yes, I've seen it where we've filed close to there wasn't jurisdiction yet. It was like, say, 170 days. And the court still let the two judges ended up talking and deciding between themselves where was the best location. And the Denver judge said, you know what, it's 170 days. They've been there. I'm going to let jurisdiction go. So you want to attack this early.
And especially if you have school-age children that are going to be enrolled in the new state, because that's going to end up really being a big factor in your case. So once they, are registered to go to school in a certain district, courts are loath to move them mid-year, mid-semester, mid whatever. So that can be a big,
even if it's not fair.
Mm-hmm.
Even if it's not fair. And I guess the bottom line is, if your spouse disappears, and especially if your spouse disappears with your kids, you need to talk to us right away. Don't wait and think maybe you can find them and talk them into this. If they're gone, if they've cut off communication, you need to talk to us immediately.
Right, because if they move with the kids out of state, we file, then we can immediately ask the court to have them brought back to Colorado. And if they move the kids after you file, there's an automatic injunction once you file that says the children cannot be removed from the state. And then the person would be in violation of that automatic injunction if they have removed them from the state. So there are a lot of options if you take advantage of them, and there's a lot to lose if you don't. All right, next topic.
Oh, sorry. I was just going to say the takeaway is just quick action. It's always better to just, if it feels wrong or it makes you nervous, get in touch with somebody. Figure out what your options are and what your rights are as soon as you can.
Absolutely. That's important. Let's talk about finances.
Oh, we have a question, April.
Oh, we have a question. What are some punishments, or what can happen if a parent takes the child out of state during the injunction? That's a good question. So you can be held in contempt, you can be fined, you can be sanctioned. The court would order the child brought back to the state. You could be punished in that your parenting time, let's say what you would have been entitled to had you not left the state, the court can give the other person more parenting time than you because you can't be trusted to do what's in the best interest of the child, which is one of the criteria. Erin, what do you want to add?
I was basically going to say that, but I will tell you that, we've seen cases within this firm, I have at prior firms where, even if somebody is a good parent, but if they cannot encourage that relationship with the other parent, and they do kind of dirty tricks like this, this gamesmanship kind of stuff, it really does end up looking bad, and they can become the minority parent in a heartbeat if they cannot encourage that other parent's relationship.
And that's heartbreaking to see sometimes, if it is like a really good parent who just, panicked or didn't know their rights or just thought they had the right to do it. That's sad to see, but it will definitely happen. We have a question in the chat. When you say filing, is that filing for divorce or separation? So thank you for pointing that out. We're talking because we talk like this all day. Hopefully you don't talk like this all day. Filing would be filing the initiating document with the court. So if you're filing for divorce, it would be filing for divorce. If you're filing for separation, it would be filing for separation. And just let me touch on that real quick. A divorce and a separation, in order to actually obtain a legal separation in Colorado, it's the same process as divorce. You basically are just checking the word separation instead of divorce, and then everything else in your filing is the same. And unless you go through that process, which is, like I said, exactly the same, except at the end they pronounce you legally separated instead of divorced, Unless you go through that process, then you're not legally separated. So when we say filing, we do mean filing for divorce or filing for legal separation, or in the case of people who have never been married, filing for an allocation of parental responsibility. So the initiating documents where you're asking the court to determine custody in your case, that's the filing we're referring to when we say there's an automatic injunction that goes into effect once you start the case with the court. There's a rule that in order for the court to have jurisdiction over you, the child would have had to have resided within the state for 180 days before you file for the court to determine custody. So that's what we're talking about, the initial custody document. Thank you.
There's
very good question.
There's another question on financials. It says, my ex hid financial assets, i.e. joint bank account, maybe property. Divorce was final in 2017. Do I have any recourse?
Oh, yes, you very well may. I'm assuming this was in Colorado. I'm assuming there was an exchange of financial disclosures where the person, you swore these are my finances, and they kept them from you. They hid financial assets from you, and they didn't disclose them to the court. So if they failed to disclose them to the court, and they made a material misrepresentation of your assets and your finances, you can go back to court. I want to say, is it 5 years? It's a long period of time.
5 years. Yeah.
5 years.
April.
Yes. So material misrepresentation, you can go back to the court and have them reevaluate your the orders.
So that's definitely to the person who posted it. I won't repeat your name just in case, but for the person who posted it, that's something you probably need to talk about with us as soon as possible, because you're kind of coming up on your deadline, and we can evaluate it and do an analysis for you. And if it looks, because one of it is it's kind of a cost benefit analysis, right? Is the financial resources that were hidden, is that going to be worth it to pay us to go and get this for you, or is it not going to be worth heartache and the legal fees to go and get it? And that's the kind of analysis we do for you, because we're going to be honest with you. We're going to be upfront with you, and we're going to let you know maybe it's not worth it to pursue this, or yeah, it looks like there's a lot of resources there. Maybe we ought to do something.
Right. We can look at it and be like, oh my gosh, have you been sitting on this for 4 years? We need to file this tomorrow. So it does depend.
I was used to, the example I always used to clients was, you don't want to find out that your ex owns a diamond mine in South Africa after the fact, right?
Oh, okay. Now, also on that, we do have cases where people come in, they're outside of timelines, but the two parties together can negotiate, like, yeah, I did keep all of your pension, or all of my pension, and I should have shared and I didn't. Let's just, rather than going to the court and seeing what happens, let's just reach some sort of agreement about how the payout's going to be. So people will, even if your timeline is sketchy about whether you'll prevail, people will reach agreement kind of when they know they were a little wrong and they don't want to deal with just the whole big court fight. So there's still some options. You just need to talk to an expert and figure out where you stand. All righty. Let's talk about, what about when you're about in anticipation of divorce, people go, they look at their bank account, they say, oh, look, $100,000. I'm going to close the bank account, put it all in an account in my name, and turn your credit cards off. What happens with that, Erin? How often do you see people moving money, shutting off credit cards prior to filing?
I see it actually pretty frequently, and sometimes they're really fair about it. But let's say it's a $100,000 bank account. They'll say, you know what, I'm going to take 50 because I want to start operating, with separate accounts. And often that's pretty fair based on whatever the circumstances are. I mean, otherwise I see it all the time. And I've had judges kind of slap them down for that and divide it as though it were funds that were in the account at the time of divorce. Because people seem to think that just because they do a bad act prior to filing, that there's no consequences, but that is not accurate. Often, especially if it's very close to the time of filing, courts will treat it as though it were in there. It can be considered marital waste, which can be a bad thing depending on what they do with those funds. So you're not without recourse if somebody does that to you.
That's absolutely right. The other thing, the court looks at it as it's kind of like temporary custody of the money. Like, you'll be required to give an accounting of the funds. If the other side wants to know how you've spent the money, what account is it in, I need all the documentation of that money, anything it's been spent on. The court will definitely support that request and, really be unhappy if somebody doesn't readily reply with an accounting of the money. So just because you have the money in your possession and the other side has the money in their possession, until the court makes a ruling, it's like you have the couch at your house and then the other party has the table at their house. The court can still go back and say who gets the couch and who gets the table in the final court orders. And it's the same for your monies, even when you move them around. Patrick, you want to add anything?
Yeah, I would just say, not to make people paranoid, but if throughout your marriage, you've always treated the finances one way, like you had one account, you put your paycheck in, your spouse put their paycheck in, and then all of a sudden that changes and the other spouse starts transferring money to other accounts, or you find yourself locked out of the accounts, maybe you need to come and talk to us. Even if you don't think the other spouse is contemplating divorce, maybe they're not. But maybe it's something that you need a marriage counselor for. But if it's something that involves your money, then maybe you need to talk to us. Or if they start wanting you to sign legal documents, this is just something on the house, just sign this on the house. You might be giving away valuable rights that could hurt you later. And that's something you need to talk to us about.
I see a chat question. Thank you, Patrick. My spouse wants to travel out of state with my special needs son for approximately 3 months, beginning in October. She considers it a trial separation, but I see it as more of a glorified vacation, which I am excluded from, but expected to pay for. How do I respond to this? Erin, why don't you go?
Well, it's an interesting question. And I guess maybe we'd want a little bit more details. For instance, is she going to be in the same spot for those 3 months? Or is she traveling around? Is she trying to establish residency somewhere? The 3 months isn't long enough, but still, is that kind of the ultimate goal? Or will she be really kind of bouncing around? It sounds like your son, well, I guess I don't know the age. If he or she is school age, well, then, I would argue that that's not appropriate. That's clearly during the school year. As far as her traveling, again, I think we need to know more details. Does she typically work? And is she quitting her job in order to make this happen? You want a little bit more information, but I guess.
Erin, it says real quick, just son is an adult with Down syndrome.
Oh, okay.
He just added it. Or here.
Right. Okay. So I see that. So obviously school is no longer an issue. Again, it really kind of comes down to you. You can say, no, I don't think this is okay. Again, we're back to whether or not your wife works and is she quitting her job to make this happen? It sounds like there's no kind of parental rights at issue here if your son is an adult. But I do think that there's some additional questions that I'd want to know the answer to.
And then, but also depends on the extent of the Down syndrome, whether or not the court ultimately will continue custody orders if you were to file, and in which case the court would weigh in on where your adult child is going. That's pretty much the unique circumstance where an adult child's movements and whereabouts still remain relevant to the court. So I think a lot of it depends, as Erin is saying, on the mindset of you and your wife. Is she looking to leave you, or is she looking to just beach hop? Because
and he's provided more information there, April. He says wife is a full-time caregiver and she's not employed outside the home. Essentially, the answer is no. your funds are her funds. You guys obviously have this arrangement where, she does not work outside the home, and it sounds like you do. And that's great. But, so that's where I'm going with that is this is also her money to do with as she pleases, essentially. And if you don't like it, you can certainly file for divorce. But I mean, it sounds like Patrick wants to chime in, but essentially I would say it's marital funds and she can spend it too.
Yeah, Erin's absolutely right. But, referring back to something April said earlier, Colorado does allow legal separation. So, and again, we don't have all the details. So that's something we want to sit down and talk with you about in more detail. But if somebody's talking a trial separation, why not make it a real separation? You can file for legal separation. We can get that set up. And if wife wants to travel somewhere, that's fine. But that way you're protected. And if it does turn into a divorce, you've already got an action going in the courts. But again, and Erin emphasized this, and she's absolutely right. This is something we need to talk about more in depth, that we can't figure it out just in a webinar. So call us. We'll set up a consult with you, and we can go over what your options are and what your legal rights are.
Yeah, I agree. I think there's too many missing pieces. This is a subtle nuance thing at this stage. And if you are concerned enough to be on our call and you want to get right, you should talk about it in more detail and see if you can create a glide path towards whatever the end result is that you want. Create that glide path now.
And April, we're being pointed to a question prior to that most recent one about the special needs son from another.
All right, here, let me grab that. See if I can. I am looking for, I think it's,
have you heard of the Bradley Amendment?
Is it
Bradley Amendment? It prohibits retroactive reduction of child support obligations. I was ordered to pay $800 a month child support for one child. Magistrate said no overnights for father due to child's age. I was only making $17 an hour at the time.
This sounds like a non-Colorado question. Am I perhaps right about that, caller?
But we can answer it in terms of child support in Colorado. Child support in Colorado is it's retroactive to the date you filed the motion to modify or filed your initial moving papers if there hasn't been an order yet. If it's your first filing, the allocation of parental responsibility, the initial filing, under Title 19, the court can go retroactive all the way back to the hospital expenses for the child if it's the initial filing under a certain statute. You can initially go back to expenses before the filing, but otherwise it's very limited, the instances in which you can modify child support retroactively. And we tell people
provided some additional information that it was in Arapahoe County in 2013. Typically, child support cannot go back that far unless there's been a mutual agreement between the parties to a change in parenting time. I mean,
it would have to be a significant change.
Right. So I think this might fall in the category of that we might need a little bit more information, but the general rule is that it typically cannot go back that far without some kind of mutual agreement by the parties. But I think we need to know a little bit more information.
Right. And that mutual agreement, the language is a modification of the person with whom the child resides the majority of the time. So it's not easily made retroactive. There's very specific circumstances. Otherwise, you can end up feeling pretty screwed. Mm-hmm. We see that. And that's why you need to get help before, when you have these questions, you should ask somebody pretty early on. But it's quite possible that you have a case that can be addressed. But on these facts, we can't tell. But it is a painful thing if you are ordered to pay child support based on an income that doesn't exist. It's way higher than you actually make. and you don't go in and try to modify it, or you can't modify it, then yeah, you're actually stuck until further order of court. A lot of times you see that, and you guys correct me, this could fall into a dirty trick actually, where the other side says, oh yeah, you don't have to pay me that. No, it's fine. And then you buy more diapers and buy more dinosaurs and buy more, you adjust because the other side said, no, I don't need that amount of child support. I'm okay. And then you look up one day and Child Support Services is saying you haven't paid since 1999, you owe the money. And you're like, wait a minute, we had an agreement this whole time. And if it's not a court-ordered agreement, you are stuck with the child support that was ordered until you modify it yourself. So it can get complicated and tricky and painful. And we suggest if you got questions about child support, definitely give us a call. We have a team approach. If you haven't been able to tell that, that's one of our favorite things. We collaborate all the time on cases. So that way you get the brain trust of, 7 attorneys instead of just the one that you've actually hired. So we really take time to listen and advise our clients. So we are at the end of our time today. Thank you all so much for joining us. We're DenverDivorceAttorneys.com. That's Denver Divorce Attorneys with an S.com. Check out our website. Give us a call if you need us. And we will see you next time. Thank you, everybody.
Thanks, guys.
Bye.
Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at DenverDivorceAttorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.